Okay, good afternoon, everyone, and welcome to this webinar this afternoon where we'll be talking about parenting and the Family Law Act. I've just kind of gone through some topics that I'm hoping will be relevant to you all as counsellors today, and I'll go through what we're going to talk about. Just a little bit about the firm and who Michael Lynch are. So we're specialist family lawyers who have been around for over 20 years now. We do have 8 lawyers in the office, and we do also have quite a few accredited family law specialists in the office who specialise in family law. We have mainly private clientele, and we also do quite a lot of publications and do a lot of marketing material, and you can find kind of the backlog of that information on the website if you wanted to have a look after. And there's also a link on the website to sign up to receive our newsletters by email when we send them out. And we've also do a fixed fee initial consultation, and I'll talk a little bit more about that fixed fee initial consultation at the end of today, but all of that information is on our website as well if you did want to access that after the webinar this afternoon. Just an overview of what we'll be going through this afternoon. So we're going to talk about obviously different kinds of parenting arrangements and how the Family Law Act intersects with those parenting arrangements. I'll be taking you through some of the concepts that are outlined in the Family Law Act, including parental responsibility, the paramount principles that the court considers primary and additional considerations, parenting arrangements, and going through a bit of the court process. At the end of the session today, I'll also be going through the domestic violence orders and how that intersects with parenting, as that may be something that you guys come across in practice, and it may also be the case that you guys are getting consent orders or court orders and domestic violence orders across your desk when you're seeing clients. And I'm also going to at the end talk a little bit about giving evidence in court and things like when you guys get subpoenaed, and then just discussing what to do at the end. So when we're talking about parenting arrangements, I guess there's really 4 ways that we can get a parenting arrangement in place. The 3 that I guess are preferred are when people can reach an agreement between themselves, so without the need for court intervention. And the 3 ways of documenting that parenting arrangement are up here on your screen. So you can either do a verbal agreement, you can do a parenting plan, or you can do a consent order. And I'll take you through the differences between those now. So a verbal agreement obviously is kind of self-explanatory. So parents can co-parent without the need to have any kind of agreements in writing if they can agree to that, obviously. So for this to work, parents do need to have a fairly high level of communication and not be a high conflict parent. Unfortunately, obviously, people that come to see family lawyers are usually in that high conflict position. So we don't see a lot of this in our practice, and it may be the case that as counsellors you're seeing a lot more at the conflict end of the spectrum. But there are people out there who can co-parent successfully without needing to put things in writing. It does require a lot of communication. It does require people to be very child focused and look at what's in a child's best interests at any point in time. But the benefit obviously being that there is a lot more flexibility with those kinds of arrangements, and you can change them and as there's different things come up for children. The next step up in formality from that is people that do a parenting plan. So a parenting plan is in writing and it is signed by the parties, but that doesn't necessarily need to be with solicitors involved. People can sit around a kitchen table and do a parenting plan, or they can go off to a family dispute resolution and do a parenting plan. So the terms of the parenting plan are in writing, but there's no standard form that it needs to comply with. People sign and date it. Again, a parenting plan is relatively flexible, so people can change it as they need to. Obviously, because you don't have to have lawyers or anything involved, it is minimal cost. However, a parenting plan is not binding and enforceable. So if you have terms of a parenting plan that provide for parenting arrangements and one of the parents is in breach of those arrangements, they can't go off to court and say, oh, well, the other parent is in breach of the parenting plan. However, a parenting plan can be used as evidence of a parent's intention at the time of signing it. So if, for example, you have 2 people that have signed a parenting plan to say that Susie will live with mum and spend 4 nights a fortnight with dad, and then mum says, no, Susie's not coming to spend any time with you, dad could commence court proceedings, attach a copy of that parenting plan to his affidavit when he files, and say, look, she was previously happy for me to have all this time and now she's changed her mind. So the court would look at that. Again, that's only one of the factors that the court would look at. So we'll have a talk a little bit later on about all of the factors that the court looks at when they're making decisions about parenting arrangements. The next level in formality, obviously, is to do a consent order. So this is when parties can agree. You can actually document your parenting arrangement in a consent order, which becomes a sealed court order and is then binding and enforceable. So you can go to court if there's been a contravention of that order, and the court will put in place appropriate punishments or fines or change the orders as necessary. So these are obviously negotiated between parties. That can either be directly or with the help of a solicitor, and that's obviously a lot of the work that we do here. So there's 2 documents that need to be filed with the court. One of them is an application for consent order, which sets out all the details of the arrangement, the names and dates and all the financial things for the children, and the next one is the minute of consent, and that's the one that you guys probably see in your practice. So that's the one that says things, you know, the parents have joint parental responsibility, the child to live with the mother, the child to spend X time with the father. So that's the document that actually sets out the arrangements that are to happen. Usually they are quite detailed as well, so they do include all your school holidays and your special occasions and things. So that's a consent order. I guess, unlike a parenting plan, like I said, it is binding and enforceable, but that also technically it is in place until children are 18, and it can only be changed with a further order of the court or if the parties agree. So it doesn't have quite that same level of flexibility. That can cause problems, particularly when you've got quite young children. So if you have children under, say, 10 and you've entered into a consent order, then obviously there might be a big difference in what the parenting arrangements are suitable for those children when they're 14, 15. Technically, unless the other parent agrees to change those arrangements, then that order remains binding and enforceable, or you need to ask the court to change that order. So there is, obviously, that needs to be talked about, and that's why we'd recommend that people get legal advice before they enter into consent orders, because sometimes you see people and they say, oh, I did a consent order, but I only thought it would go for the next 2 years and then we could look at it again. So I guess, yeah, important that people get legal advice before they enter into that document, because it can have long-standing effects for people if the other party won't agree to change it. Most separated couples are actually able to make arrangements for the care of children that work for the children and them, and lawyers or the court don't necessarily have to be involved. Like I said before, that's obviously not a lot of the people that we see coming through our doors, and probably not who you see either, but obviously there is a high percentage out there that do manage to do that. If people can't agree, then the Family Law Act sets out what considerations the court must take into account when determining parenting arrangements. So as lawyers, when we give advice, obviously we will refer to going to court, legislation and cases. And we always say to our clients, look, that doesn't mean we're necessarily going to end up in court. Court is your last resort, obviously. But that's how we give advice about what parenting arrangements might be appropriate. And we can use that as, you know, experience of this is how the court has looked at a similar case before. At the end of the day, obviously, ideally, parents will make their own decision about parenting arrangements that work for the family. And that's really because obviously every circumstance and every child and every case is different. So it's very difficult for us as lawyers and for judges when they're making decisions in court to make decisions that will work for the family. Although we do get, you know, as much evidence as we can from everyone, and we get expert psychologists involved to give evidence about what might be best for children. It's just not quite the same as parents who know their children actually making that decision and having ownership over what parenting arrangements they have. So that's why we spend a lot of time encouraging people to come to a negotiated agreement rather than going off to court and having someone else make the decision. Okay, so the first concept we're going to talk about this afternoon is parental responsibility. So this is probably something you guys will have seen in orders or you would have heard people talk about. So parental responsibility is basically the concept, and this is in the legislation. So under the Act, there is a presumption that parents have equal shared parental responsibility when making decisions about major long-term issues for children, which include religion, school, what name a child is called, health issues, and where a child lives if that affects a parent's time. So all those really major issues for children should be decided jointly by parents because they have a joint parental responsibility. The day-to-day issues are considered differently by the court, so the court doesn't really want to get involved in day-to-day issues if there are disputes between parents, unless of course that is a risk issue. So sometimes we have clients come in and they start talking about, parenting styles or what the kids are eating at someone's house or when they're doing homework. Unless that's something that is going to be a risk for the children, then the court is probably going to say that's really a parenting style difference, and a difference in parenting style is not really something that the court's interested in. When it's these major long-term issues, so things that are going to have a long-term effect on the children, then the Act, the Family Law Act, does say that the parents should be making those decisions jointly. If parents are unable to make a joint decision about those major long-term issues, then the court will make a determination, and we'll talk about how the court looks at weighs up all the different options. So the presumption in the Act is that parents will share parental responsibility. However, that presumption is rebutted where there are issues of family violence and if it is not in a child's best interest for the parents to share those responsibilities. So although the presumption is there, it's not an automatic right. It can be rebutted in those circumstances. So I guess the thing is, it is a really important responsibility, and the court will take it very seriously if there is going to be sole parental responsibility awarded to one parent or the other. And there would have to be some really strong evidence and some really, I guess, concerning risk allegations or communication problems between the parents before the court will consider awarding someone sole parental responsibility, because it does have such long-term effects for children. So that's the first concept. The principle, I guess, paramount principle of the Family Law Act is something that we often come back to when we're giving advice, and the courts always come back to this when they're making decisions, and that's the best interests of the children, and that's the paramount principle when the court's making any decision in the court. So whether that's interim or final, we always come back to that, and we spend a lot of time redirecting clients to think about that when we are taking instructions from them or when we're negotiating with people. So there's a number of ways that the court determines what's in a child's best interest, and we'll go through what's called the primary and additional considerations, which are under Section 60cc of the Act. So this overarching principle guides all parenting decisions made in court, and like I said, we do spend a lot of time refocusing clients to think about that. Understandably, obviously, separation is really difficult for people, and people are emotional, and some of their emotion may be directed at the other parent. And sometimes that can mean that they're not necessarily making child-focused decisions when they're giving instructions or when we're talking about parenting arrangements. So we do try and spend a lot of time refocusing clients back onto, is that really in the best for the kids? Don't you think that the kids might like X or Y? So I'm sure you guys see a lot of that misdirected emotion as well in your own practices. So the primary considerations, so when the court's looking at how they determine a child's best interest, they look first at the primary considerations. So the benefit to the child of having a meaningful relationship with both parents. So generally it's accepted that that's best for kids to have that meaningful relationship with both of them. And then also, obviously, if there's any need to protect the child from any physical or psychological harm or family violence. So I guess that's the two primary considerations. Obviously, if there's any need to protect children, then the court will take that into account. Otherwise, the court is trying to ensure that both parents are able to facilitate the child having a meaningful relationship with both of their parents when that's safe for them. Okay, so the additional considerations that the court looks at after we've looked at those ones. So obviously, if there's views expressed by the children, taking into account that child's maturity and understanding. So this is a really important one that comes up quite often. There is no age at which a child can decide or tell the court where they want to live. So often we hear clients come in and say, oh, well, now that Johnny's 12, he can tell the court where he wants to live. Technically, the court has jurisdiction to make parenting arrangements until children are 18 years of age. Obviously, their views are one of the considerations, but it's just part of the overall, I guess, picture that the court needs to look at. So it's not determinative at any point, but obviously the older and more mature a child is, then their wishes are going to be more heavily weighted, but it certainly doesn't mean that they can, I guess, make the decision. It's a common misconception that we hear very often. I'm sure you guys do as well. Okay, the other considerations, so the nature of the child's relationship with each parent and any other kind of extended family, the extent each parent has taken to participate in decision making and spend time and communicate with the child, the likely effect of a change in circumstance for the child, including separation from a parent or relative, and something like the effect of separation, that's probably going to be particularly relevant where you're talking about relocation matter, where one parent wants to move a significant difference away, then that's going to be a massive consideration for the court. The practical difficulty of spending time and communicating with the other parent and the expense or any other difficulty of that time. And again, that's one that often comes up when we're looking at relocations. Who's going to pay for flights and school holidays if that's the only time that's going to be there? Okay, on to the next page. So the parent's capacity to provide for the child's emotional and intellectual needs, maturity, sex, lifestyle, background of the child and parents. If a child is Aboriginal or Torres Strait Islander, their right to enjoy that culture. Any family violence, including any family violence orders. And we'll talk a lot more about family violence orders and domestic violence at the end, like I said. Whether an order should be made that would be least likely to lead to further proceedings in the future, and basically anything else that the court thinks is relevant. So if there's any other facts that come into it, as I said before, the court has a broad discretion just because of the nature of family law, and every case is different, every child is different, so there's often very different fact scenarios depending on the case. Okay, so that's kind of the background and the principles that the court considers. So obviously, the parenting arrangements that we're talking about, that's what the court is ideally going to determine by looking at all those things. Obviously, sometimes there are disputes in the court about those major long-term issues we decided. So sometimes people will be okay with parenting arrangements but not be able to make a decision about what school a child attends, or what religion a child practices. So that's obviously a bit different, but the more common stuff we see is when parents are unable to agree on what kind of time arrangements are there for children. So usually parenting arrangements obviously provide for the children to live with one parent and spend time with the other parent. So we don't use the term custody or residence anymore. That's kind of gone out. So we have the live with parent, which is the primary carer, and then we have the spend time with parent, who is the other parent spending time with the children. Obviously, as you guys probably know, there's provision for school holiday time, special occasions, overseas travel, any other circumstance that may arise during the course of parenting. So we might have time for telephone time, we might have people attending school events. So consent orders are quite detailed, and we do try and deal with any contingency that may come up over the course of a child's life, I guess. As I said before, ideally parents are going to agree on parenting arrangements. However, if that doesn't happen, obviously then the court's going to have to make orders and make a decision, as I spoke about before, what's in a child's best interest and looking at all those factors. A lot of people, I guess, that do commence court proceedings doesn't necessarily mean that they have to go all the way through to a court making a decision. Often people commence court proceedings and then manage to resolve it at some point along that process, and they can then enter into consent orders, and we spoke about them before. Okay, so a little bit about, I guess, how the court makes time orders. So when we've got equal shared parental responsibility, and as I spoke about before, we do have equal shared parental responsibility. So then the court must look at, is it in the child's best interest to spend equal time with each parent, and is that practicable? If the court says no, that's not going to work, then is it in the child's best interest to spend significant and substantial time with the other parent, and is that practicable? And then if the court says no, that's not going to work either, then we just need to make orders that are in a child's best interest, taking into account those primary and the additional considerations. So that's kind of the step-by-step process that the court goes through. That's often misconstrued by people. First of all, people think that equal shared parental responsibility means that they are entitled to equal time. I guess time and parental responsibility are two different concepts, and they don't necessarily mean the same thing. So parental responsibility is that decision-making power. Obviously, time is the time that the children are spending with each parent. So very different, I guess, but often misconstrued by people reading legislation or reading about this. So obviously the court's first port of call is going to be, okay, does 50-50 work? When we're looking at substantial and significant time, generally the court says that that includes time on weekends, holidays, and school days, and allows a parent to be involved in the child's daily routine, occasions, and special events. So significant and substantial time is usually allows the non-primary parent to do a school pickup. It gives both parents weekend times, but it also means that both parents are doing the school night stuff. So, you know, both parents are having to do homework, pack the lunches, pack the school bags. So it's, I guess, a bit more of an equal division. We've certainly moved away from the, you know, alternate weekend, Friday to Sunday, where the only thing is then getting to have fun on the weekends and the other parents doing all the homework. So it's trying to spread out those responsibilities and allowing parents to be involved in all aspects of a child's life. So the court, when they're looking at what time arrangements are reasonably practicable, so that's all the really logistics things. So how far apart are parents living? Obviously, if you've got parents living on opposite sides of Australia, then it's not practical to have a 50-50 arrangement. The parents' capacity to implement the time arrangements and their capacity to communicate to resolve difficulties that arise. So it's really important when people are co-parenting that they can communicate on some level, and doing a shared care arrangement, so a 50-50 arrangement, does require a lot of cooperation and communication between parents. So sometimes the court may say, well, even though it's best for kids to have a relationship, if they're very high conflict parents, the court may say that they're not really able to facilitate that 50-50 shared care arrangement. And that might mean that it's not, I guess, in the best interest of children, particularly if there's high conflict and they're going to be interacting a lot. So the court needs to look at, I guess, all the circumstances in the relationships, including the parents with each other and the parents with children and any new partners and things as well. Obviously, the court needs to look at the impact of the arrangement on the child. So what's the arrangement look like? Does that mean the child has to take 10 million bags to school 3 times a week? Are we doing block time? How does that look? Is the child, you know, old enough to cope with that kind of distance away from their primary parent? All those things. The ability of both parents to facilitate a relationship with the other parent and any other relevant matters. So it's really important that people can facilitate a child having a relationship with the other parent. And that comes down to, you know, ensuring that people aren't denigrating the other parent, ensuring that they facilitate phone calls and give the kids privacy, ensuring that they are able to have some level of communication to keep the parenting going, because it is, I guess, a joint process that's happening in 2 different households. So it's really important, and that's one other thing that we spend a lot of time with clients trying to redirect them to say, well, you know, often people might say some things about the other parent, and that's, you know, in the emotion of it all, that might come up, but I guess it's important that they still can show that they can facilitate a relationship and that they appreciate the role that the other parent has in the child's life, and that they are willing to keep ensuring that that person is a part of the child's life. So facilitating relationships is really important as well. Okay, so a little bit about the court process. So what happens when people, I guess, can't resolve it between themselves and they then have to file court proceedings to get the court to assist. So one parent will usually file an initiating application. That will come along with an affidavit, which is their story as to, you know, this is what's happened, this is a bit of background, and this is why I'm in court, and a notice of risk. The notice of risk gets filed to identify to the court if there's any abuse, mental health, alcohol use problems, and that gets filed with the court as well so that they know if there's any urgency. And basically, the initiating application says to the court, these are the arrangements that I think are in the child's best interest, and this is what orders I want the court to make. Before a person can file in court for parenting arrangements, they need to first attempt family dispute resolution or mediation and show to the court that they have made an attempt to resolve matters before they've gone to court. So that can be done through Relationships Australia, or there's also private practitioners that do family dispute resolution. So one parent can initiate that provider will then contact the other parent and invite them to attend a dispute resolution session. If the other parent declines, then the inviting parent will be given a Section 60I certificate. If they both attend but they don't manage to resolve it, they'll get a Section 60I certificate. And I guess usually the aim of an FDR is to do a parenting plan. So sometimes people might go get a parenting plan, but they want to get that into consent orders, or they want to, you know, review the parenting plan, so they will get a Section 60I certificate as well. So once you've got that Section 60I certificate, that can be, I guess, it gets attached to your initiating application, and that means you can file. If there is some urgency in a parenting matter, then you don't need to go through that process of FDR. The big ones for urgency we see are obviously if people have unilaterally relocated with children without consent of the other parent, if it's been quite a significant time since a parent has seen children, particularly young children, if people have unilaterally enrolled kids in a different school. So those kind of urgent issues can mean that you can get around that Section 60I requirement. And it's important, I guess, as well, that that Section 60I certificate is only valid for 12 months. So if you've done FDR 18 months ago, you will have to attempt it again before you can commence court proceedings, unless there is one of those urgent reasons. So the court documents are filed with the court. You will get a court date, and then you need to serve those documents on the other parent. The other parent will then have time to file their response, outlining, I guess, the same kind of thing, responding to your evidence and talking about what they say is in the best interest of the children and what arrangements they say are best. As I said before, most matters that commence in court do actually resolve at some time along that court process, whether that's directly through negotiations, whether that's with solicitors, mediation, or sometimes people just manage. For example, once they've got interim orders in place, they may decide that they're happy for those interim orders to continue, and they agree to make them final. So there are a number of ways people can resolve it, and I think it's something like 95% of people that do start court proceedings do manage to resolve it. So once a matter is in court, the judge will make orders to assist parties to progress their matter. So the court is, I guess, encouraging people to resolve matters. Often one of the first things the court will do is order that people participate in a family report. So that's a social worker or a psychologist interviewing the family, observing the children with the parents, and providing quite a detailed report to the court. And that's, I guess, the way the court gets evidence about what's in a child's best interest. So the court won't speak to children generally. The judge doesn't have an opportunity to talk to children. So the family report is really the way that the court gets evidence about you know, those things we spoke about before. So child's wishes, what the arrangements are like in each house, you know, how the relationships are going, and gives a recommendation about what arrangements moving forward are best for the kids. Yeah, and as I said, depending on the age of the kids, so the family report writer will interview kids in an age-appropriate way if it's appropriate, and then obviously depending on their age and their maturity, which the family report writer will flush out, then that goes into the report as well as part of their wishes. And the court process, I guess, is angled at people to resolve it, and one of the big motivations for people is the court process is not particularly quick. So from filing to getting a final hearing date can be anywhere between, you know, 12 months to 2 years just to get the judgment before a judge. So it's not a quick process. There is plenty of opportunity along the way for people to try and resolve it if they can. And obviously 2 years can make a big difference to how old a child is and what arrangements they may cope with. So it can encourage people to settle along the way. Okay, so that's kind of given the 101 on parenting matters. I'm going to talk a little bit now about domestic and family violence and how that intersects with family law and parenting arrangements. So just as a bit of background, the Domestic and Family Violence Protection Act is the piece of legislation that governs domestic violence in Queensland. So Section 8 of the Act provides a very broad definition of domestic violence. And the definition is behaviour towards a person that is physically, sexually, economically, emotionally, or psychologically abusive, coercive, threatening, or controlling. So we do have a very broad definition of domestic violence in Queensland. We've certainly moved away from it needing to just be the physical violence. And so I guess that has broadened the number of applications that are made and the allegations that may be made in any family court proceedings. The Act does helpfully go through a list of examples of domestic violence as well, just to, I think, demonstrate how broad that definition is, and to change people's perceptions of what domestic violence is. So it's a non-exhaustive list, but some of the things are listed there. So obviously damaging or threatening to damage property, coercing a person to engage in sexual activity, threatening animals, following a person, so stalking, repeatedly texting or emailing a person, stopping a person from staying in touch with friends. So a lot of this, as you can see, goes to more that controlling and coercive violence. Selling people's property, asking people to sign loan documentation, threatening suicide is one we see quite often. And also the ones that we're coming across more, I guess, is related to technology. So, you know, texting, having tracking technology on phones, or the revenge porn stuff as well. So the judges in the magistrates court are making quite specific orders about some of that stuff and about social media orders against people. So it's something that the courts are more attuned to, I guess, than they have been previously. Okay, so talking about DV orders, so that's domestic violence orders or protection orders, depending on the terminology, and how they interact with parenting orders. So parenting orders in Queensland are made by either in Australia are made by either the Federal Circuit Court or the Family Court. That is a federal court. Domestic violence orders are governed by Queensland legislation and are therefore made by the State Magistrates Court. So a magistrate must always consider family law orders when they're making a domestic violence order. So the magistrates are supposed to ask for copies of parenting orders and then have a think about whether the terms they propose to put in any domestic violence orders may conflict with the terms of the parenting order. Because we've got the federal versus the state, then the parenting order does technically override the domestic violence order. So if, for example, you have a domestic violence order that says that someone is not to contact the aggrieved at any time, And then you have a parenting order that says that on Wednesday they can contact the aggrieved between 5 and 5:30 for the purpose of talking to the child. Then technically they aren't in breach of the DV order when they're complying with that parenting order. So very different, obviously, if they ring at 4:45, then they are in breach of the DV order. It's best practice, I guess, to include a family law exemption in the DV order, so it just reduces that conflict, and I'll show you an example of what I mean by the family law exemption a little bit later on, but basically it just means that that condition won't operate. Usually we just put in something along the lines of, that they be able to contact the aggrieved as agreed in writing or pursuant to a family court order for the purpose of having contact with the child or something along those lines. So I think I've got an example later on in the slides, but I guess it's better to include that specifically just so there's no confusion between the police or people trying to enforce orders. The magistrate must consider whether to amend, vary or suspend family law orders to resolve any inconsistencies between the protection order. So although that's in the legislation, in practice, I haven't seen that happen very often or at all. So I don't think the magistrates are really willing to change the family law orders or suspend them. I think it's more likely that they're going to put in that exemption to say, well, you're not in breach of this order when you're, for the purpose of contacting children. So although the magistrates do have that power, I haven't seen it happen very often. Okay, so obviously there's a whole variety of different conditions that can be included in a domestic violence order, and what conditions are included will obviously depend on the facts of a case. So the court has quite a broad power to include conditions. The standard condition must be included in any domestic violence order, and the standard condition is basically that the respondent be of good behaviour and not commit domestic violence against the aggrieved. The magistrate also needs to look at whether children should be named on the order, and then there's the same condition that they be of good behaviour towards the children named. So generally, if there's children under 18, particularly when we've got ongoing parenting negotiations or conflict, then the court will include children as named persons on the order. You should also consider, obviously, if there's any other family members or associated parties, so sometimes new partners or mother-in-laws or anything, they can be named on the order as well, obviously if it's relevant to the allegations that are being made. Obviously, so there's other specific conditions. The ones we see often are not to approach a person, not to be at a property, not to approach a school where the children attend, not to contact the aggrieved. The common one we see obviously is not to approach within 100 metres of where a person lives or works. But there should be a reason for requesting a condition. So obviously, if someone's being harassed or threatened by text message, then there should be a condition that the person not be able to contact them by phone or text message, because it just means that then any of that ongoing behaviour will be a breach of the order. Another one that we do see regularly is called an ouster order. So that's when the court makes an order, I guess, excluding someone from the home of the aggrieved. That obviously can have really serious ramifications for people and can have, I guess, ongoing ramifications for parenting arrangements, depending on what arrangements we've got in place. So that can be made on a temporary basis. So often that is made by police when they attended a property following a DV incident. So they're called to the property, there's been an argument. They consider that one party needs to leave the home to let things settle back down. They put an ouster condition in. That can be for a set period of time, 24, 48 hours. If that goes to court, the court can also make the ouster order on a longer term basis. So at the first court date, when a DV matter comes before the court, the judge will look at the application and say, okay, well, I think there needs to be a temporary order to protect the aggrieved. In 99% of cases, a temporary order is made at that first court date. The only evidence the judge has at that point in time is the police application or the application by the aggrieved. So the evidence hasn't been tested. It's one side of the story generally, but the court, I guess, needs to act very cautiously to protect vulnerable people, and they will usually make a temporary order on whatever conditions they think are necessary in the circumstances. So that ouster condition can be part of a temporary order. If an order is made on a final basis, then it can also be included on a final basis. This is that family law exemption that I spoke about before. So that's just an example of the wording we would include when we're involved in domestic violence matters, just to really spell out that if there is a conflict, that the parenting arrangements won't be in jeopardy, I guess. So for example, there's a condition that the respondent not contact the aggrieved, and we would include under that, except for the purpose of having contact with the children as agreed in writing between the parties or in compliance with an order of a court, or to attend a court or tribunal agreed conference or mediation. So it just means that it still means obviously that people can't contact aggrieved just to have a discussion about how she's not signing documents or there's no property settlement. So it is still restricted in what they can talk about. And obviously any contact needs to be agreed in writing. So often what we would do at a domestic violence day is, if there's children, we might try and negotiate a parenting plan on the day that says that someone can call on twice a week between these times. And that just spells out then that they're not going to be in breach of that order if there aren't parenting orders obviously already in place. So just something, again, it's one of those things where people probably need to ensure that they're getting legal advice before they get DV orders made, because it can affect, I guess, parenting arrangements, particularly when they don't have parenting orders already in place. Okay, so the court, obviously there's certain elements that the court needs to be satisfied of before making a final protection order. As I said, temporary protection orders are generally made at the first court date and the evidence isn't tested. If the matter proceeds through to a hearing and someone is contesting that there shouldn't be an order made, then the court needs to be satisfied of these three things to make the order on a final basis. So the first is that a relevant relationship exists. So spouses, ex-spouses, ex-girlfriend, boyfriend, family relationship, that will satisfy the court of that part. The second element is that there's been an incident of domestic violence. As we spoke about before, the definition of domestic violence is very broad. So generally that can be satisfied relatively easily. The third element is whether it's necessary or desirable to protect the aggrieved. So that will be where we have most of the arguments if the matter's at a trial, and where we try and convince the judge that it's not necessary or desirable. That's going to be very fact dependent on, what the arrangements are, how long the incident's been, whether it was a one-off incident. So all those kind of things that will come into it. So that's a little bit about domestic violence orders and how they intersect with parenting. At the end, I just thought we'd talk a little bit about, I guess the thing that you guys might come across is when you're asked to give evidence in court for parenting matters. So there's a couple of ways that you may be asked to give evidence. Obviously, sometimes you may be subpoenaed by law firms or parties acting for themselves in parenting or domestic violence proceedings. So obviously, if you are issued with a subpoena, it's a court document and you must produce documents or attend court. So they may either ask just for your file, or they may say, can you come and give verbal evidence in court? You are being compelled then, and that means that you do need to comply, obviously. If you are attending on a subpoena, you are entitled to be paid conduct money. You can ask for costs of attending court, so time spent out of the office, and there are quite serious penalties if you don't comply. So obviously I would recommend that you comply with subpoenas. If you think there may be grounds to object to a subpoena because it's irrelevant or it's too broad, and there are quite limited reasons you can object, then you really should be seeking legal advice prior to any time limits for objections passing, obviously, because it is really important that you comply with those time limits, and the court will take it seriously if you don't. The other way that you may be asked to give evidence is a solicitor, for example, writing to you and saying, I'm acting for this person, their child, or they are seeing you, and we would like you to write a report, or we would like you to write a letter. If they do that, they then may also ask you to attach it to an affidavit, and that then means that you're becoming, I guess, an expert. Usually it will say, here's my report and here's a copy of my CV to show my expertise, and that is then filed in the court. That does mean that you could be called to give verbal evidence at trial, and you may be cross-examined on the report. So I guess that's voluntary. You don't have to agree. If you get a letter from a lawyer asking you to do that, you don't have to agree to do it. That's really a matter for you. Okay, so in conclusion, I guess the takeaways from the session today are obviously encourage clients to seek advice early from a family lawyer. We spent a lot of time counselling clients as they're going through a really hard time and referring them to counsellors, and I'm sure you guys see the other side of that, people saying, I don't know what's happening in court, or I don't know what to do about this. And I guess the best thing is to refer them to a solicitor to get some specific family law advice. There are some community legal centres in Brisbane that do really great work and provide family law advice. So I've listed some of them there, and there's a link there to be able to get in touch. As I spoke about at the start of the session, we do fixed fee, no obligation initial consultations. So the fees for that are $385 for the solicitors or $440 for the accredited specialists. Those appointments, usually they go for between an hour and 2 hours, and we can go over the law, how it applies, and clients can ask questions. Often people bring in lists of questions, or they have court documents with them. So it's a really good first port of call for people to get that initial information they need. And then we can kind of give them an idea of steps moving forward, and there's no obligation for them, obviously, to engage us moving forward. So it's a really good way for people to get the information they need up front. So I hope that's been really helpful. Thank you so much, everyone, for tuning in. And like I said, if you do have any questions, send us an email and we'll go from there. Thank you. Have a good afternoon.